All right, it is March 12th, at just past 4:30 PM. This is the Personnel Committee of the City of Green Bay. Attending and present on the committee is Alder Hutchinson, Alder Johnson, and Alder Galvin. I have not, oh, I see Alder Burnett on the screen, so we have a complete committee. On to the agenda. I'll entertain a motion.
So approve,
Is that so approve?
well, move to approve the agenda.
That's a new one?
Well, yeah.
Second, anybody?
Yeah.
Anybody?
Jesse seconded.
Oh, okay. All those in favor say aye.
Aye.
Aye, that passes unanimously. On to the minutes.
Move to approve the
I was
minutes.
waiting for that King Hutch motion. Second.
Okay, all those in favor say aye.
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 And that passes unanimously. On to regular business. For consideration with possible action on a request to fill the following position and all subsequent vacancies resulting from internal transfers. Conservation Corps Field Assistant.
Move to approve.
Second.
All those in favor say aye.
Aye.
Aye, and that passes unanimously. Item 2, for consideration with possible action to discuss the impact of adjusting review dates for those hired 2017 and earlier who have a December 1 review date. Staff.
Yeah, we've had this discussion for a few meetings, and I think the last meeting we talked about was for employees that still have the performance review date in December 1, to look into either moving them to the original hire date or moving them to a different earlier month. And the thought was, these employees were the ones that were moved to December 1st in 2017 when the pay plan was redone in 2017. And these also were employees that were not moved due to leapfrogging or making sure other less senior employees didn't leapfrog them. So we have about 60 employees that are in that situation. It would cost about $92,000 this year to move them to the original hire dates, or it'd be $40,000 to move them to June 2nd.
Wait,
So
how much for,
$40,000 if it was moved to June 2nd. And then $92,000 if it was the original hire date.
and I misheard, 60 or 16 employees?
60.
60, okay.
So these are typically employees that, there isn't multiple in their position, so there's really no seniority leapfrogging issue. They might be the line position, so you don't really have to move them up for leapfrogging issues. So it's, obviously it's up to the personnel committee. The recommendation from staff is that if you do choose to move the performance review date, we prefer June 2nd, because it's a little bit easier for our, payroll and HR to administer that. It's all on the same date versus if it's a different date for every single person, that's 60 different dates. And then we would ask if you do move to approve that we then come back to either personnel or finance to determine a funding source. It's also possible that we might not need to designate that. It could just be under the salary line item. So that's for the personnel committee to consider. And obviously, if we're asking for June 2nd, decision doesn't have to be made today till we have time to do it.
True. Any questions for staff? If not, I'll entertain a motion.
I'll move to approve the June, moving all dates from December to June.
Before we go there,
Mark, did you want to say anything?
yeah, I was going to say, does anyone on the floor want to say anything to address this?
Not at this time. I'm observing, but I will chime in when need be.
All right, thank you, Alder Stoyer. A motion to open the floor?
Second.
All those in favor say aye.
Aye.
Aye. Okay, that passes unanimously.
Okay.
You just usually have something to say, Mark, so we assume.
Well, only when I think it's
Yes.
pertinent.
And sometimes the mark on the screen thinks we're talking about him.
I'm not sorry. Mark Berglund, 806 North Broadway. I guess the first thing I'd like to say is thank you. Thank you to the HR department for digging into this a little bit, and you kind of know my speech. When I come in front of you, I'm always, haranguing on this, and I hope you're just not looking at this to shut this guy up and make him go away. But I appreciate that, and I appreciate you guys considering that. And I know, the big sticking point is always the funding. I get that from experiencing all of this, that usually if you want to do the right thing, it's a good thing, but there's always how are we going to pay for this? And I get that, at the $40,000, I understand that. So basically, I want to say thank you to everybody involved, just for checking into this, because I know you didn't have to. You know, so this is kind of over and above is the way I feel. And then the only other thing that I don't quite understand, and I'm not really too much of a numbers guy, you know, Paul Mwazova from DPW, he's the numbers guy. That moving everybody to June 2nd will cost $40,000, you know, and I'm a December 1 guy. But the part I don't understand is you're moving 60 guys, 60 workers 6 months forward. So that costs $40,000. Now, if you were to move them to their review date, all of a sudden that costs almost double, or actually more than double, goes from 40,000 to 92,000. And the thing that I don't quite understand is how does that number get up so high? It would almost be as if everybody on these December 1 dates are gonna have their start date somewhere the first part of January. How that number more than doubles when you're moving them 6 months, and then you look at moving them another 5 months, and the number goes from 40,000 to 92,000. Like I say, I don't know all the intricacies of this, but that number just baffles me a little bit. And actually, in my case, and this is kind of where I fall on my own sword, that I'm a December 1 guy, but I started in August 4th. So it'd be best for me if you moved everybody to June 2, because then I'm moving up 6 months instead of 3 or 4 months. But that being said, if they moved it to my review date in August, that's only going to lower the cost. So if you get what I'm saying here, you know, I don't understand how the number balloons so much to get to the start dates when it's X amount of dollars to move this far, and you're not even moving that far again ahead, but the number goes up more than twice.
And we can ask that question of staff when we close.
Well,
the
that,
floor.
you know, and that's the only thing I was kind of going back and forth. Do I even want to say anything about this? You know, basically it's because I don't understand the math of it, and I'm kind of shooting myself in the foot. Because, you know, if it went to my start date, I'd actually come out shorter than, you know, than if it went to June 2nd. So, anyway, that's the only thing I was wondering. But anyway, the main thing is thank you for everybody, you know, just for considering this. Hopefully you can find some funding. It'd appreciate it. And it's all the long-term guys that you know, so, and I've been spreading the word that they're trying to happen, and you know, to all the long-term guys that I work with, and we're all appreciative. And we just wanted you to know that. So, thank you.
Thanks, Mark.
Thank you.
Anybody else?
Motion to close the floor?
Second?
All those in favor say aye.
Aye.
That passes unanimously. All right,
Joe, you heard the man.
I did. Well, we ran the numbers in HR, and we did have finance review them, you know, kind of spot check, but we can double check on that. Yeah, I mean, it does, I give her what Mark is saying in the sense of how does it double when you're just moving up to January 1, and that's just the formula we put in, so maybe there was an error there, but if it's not 92, it's more than 40,000, so.
I would assume maybe you've got 60, 70% right
Yeah,
of your workers that are before that date, or maybe they're your higher wage earners that are there.
Yep, it could be, yeah, it could be a lot of factors, and also it's, sometimes pay periods fall on different dates, so, you know, there might be more pay periods June 1, closer to January than June 2nd as well, might be 1 or 2 more. And that's 60 people for a couple of pay periods.
Is it possible, Joe, because, you know, there's obviously perfect, and then there's sometimes what we can reasonably achieve when you're working with a lot of individuals and variables. When we look at like this, so Alder Hutchinson was at least attempting to make the motion to do the June 2nd option, that $40,000. Is it plausible that we can absorb that in our existing personnel budget by, you know, attrition or open positions?
I don't want to speak on behalf of finance, but I think it's pretty plausible, especially with the number of vacancies we have throughout all of our departments right now. I think it's pretty likely.
That makes me more comfortable, you know, with a motion like this when you're in the middle of well, not a middle, but, you know, you're already a fourth way through your budget. Like, it just, because obviously you like to make these decisions during budget season. I know Alder Burnett talks about that a lot, but that would make me very, very comfortable with the motion if we can find a way to do that.
Yeah, so I mean, if even if the motion wants to bring it back to April 9th to verify that, then we can do that.
Okay.
Yeah, I'd move to look at the option to move to June and bring it back to the next meeting, so we can reconsider it and approve it if we so desire.
We got a second on that? All right, all those in favor say aye.
Aye.
Aye. And that passes. All right. Item number 3, for consideration with possible action on a request to approve the 2024 labor agreement between the City of Green Bay and International Union of Operating Engineers, AFL-CIO, Local 420 Bus Mechanics. Staff.
So you do have in the packet the summary that was put together by HR Manager Falk, and then the strike-through contract, and you also have Director Becky Hughes here as well. So does the committee have any questions or want them to?
I do not.
Mutually agreed upon?
Alder Sawyer? Alder Burnett? Nothing? Okay, Alder Hutchinson? Entertain a
approve.
motion.
Second.
All those in favor say aye.
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 Aye. And that passes unanimously. Item number 4, for consideration with possible action on a request from Alder Weary for external HR investigation to be initiated regarding the apparent retaliatory disorderly conduct charge filed versus Attorney Janet Angus after she submitted a valid election complaint to the WEC. The committee may convene in closed session pursuant to state statutes.
Well,
Oh, yeah,
I'm gonna make the motion first.
What's that?
Do we
Yeah,
need-
that's closed session, should have been italicized, that's on me, I put the agenda together.
All right.
So.
Do we need to go into closed session, or can we talk about this openly?
Yeah, our hope is that we can talk about it in open session. We do have, Chief Davis and Attorney Bunder to talk through kind of the process and the timeline of the situation. If we do get in a situation that talks about performance or any type of discussion that might impact our litigation strategy, I think Attorney Bunder will let us know the guardrails, and we can go to closed session for that. But we're hopeful we can have this in open session.
Great.
Okay. All right.
Chief Davis.
Good afternoon, everyone.
Chief?
So I will do my best to piece together for you the best timeline that we can for how all of this happened. And then there are some parts of this I think the city attorney will address that just happened outside of the police department. But this incident that gave rise to this whole situation happened on April 5th, 2022, so almost 2 years ago. This was in the 8 o'clock hour in the morning. There was allegedly an incident that occurred in the city clerk's office and also in the hallway directly outside the clerk. There was an individual who we later determined was Ms. Angus, who somehow, when this was what was reported to us, somehow got herself in the middle of a conversation between our city clerk and a voter who was dropping off a couple of absentee ballots, her own and her husband's. She was dropping off her husband's ballot apparently because he was physically unable to do so himself. There was some level of alleged disturbance, which was reported to me to have reduced our voter to tears and brought all the activity in the clerk's office to a halt. At that time, that being election day, we had a Detective Brad Biller, who was working in City Hall to provide security for election day, and he was apparently up on the 4th floor when this happened and not physically present in the clerk's office when this happened. The city clerk had some conversation with Detective Biller about the incident. What I am not clear on is exactly what all the details of that conversation were. And then we fast forward to April 25th, and I will tell you that I don't remember exactly when I became aware that this incident had happened, but it was sometime between Election Day and April 25th of 2022. And what came to my attention, and I apologize, I don't remember who relayed this to me, was that there had been this disturbance, that we'd had this voter who had been impacted. Normally in a situation like this, without a complainant, we really don't get involved as the police department. You know, as I'm sure Alder Galvin knows, our process gets initiated when someone makes a report to us. On April 25th of 2022, I received a call from the city's Chief Operating Officer, Joe Faulds, about this situation, and the concerns that were expressed to me at that time were, number one, you know, again, we had a voter who was impacted by this alleged behavior, and then we also had business that was supposedly came to a halt in the city clerk's office. To me, as a police professional, that could be at least an episode of disorderly conduct. We don't, you know, it's outside the bounds of legal behavior normally to create a disturbance that is great enough that it stops what's going on in a place of business, or that it has that impact as was described to me. And so Joe Faulds asked the police department to take a look at this incident. I want to be clear about one thing, that in no way did I take this as an order. Under the statute, as I understand it in Wisconsin, the only person who can give me an order is the mayor, and this was not the mayor. This was a request from City Hall that we look into this incident. And at that point, the decision that I made was based on a few very specific things. One, I have a report of an individual who was alleged to have been very negatively impacted by this behavior, reduced to tears, while trying to conduct business inside City Hall. And then I have an office in City Hall that was not able to, that had its work stopped because of the disturbance. Those are potential disorderly conduct issues, and so I chose to ask that we have someone investigate this. I met with Detective Biller. I did this through our chain of command. I asked our detective commander to assign someone to this. And I met with Detective Biller, who I thought was a pretty good choice for this, number one, because of his experience level, but also because he's familiar with working security at elections and understands the comings and goings at City Hall during these things. And the specific conversation that I recall very clearly having with Detective Biller was, go find out what happened. And if there's a criminal offense, we'll deal with it. And if the answer that you get is that there isn't a criminal or other offense that's happened, then that's the answer. But let's go find the answer to the question. So that was sort of the end of my direct involvement in this for a while, but I do know that Detective Biller conducted an investigation. He wrote a police report, took some statements from the parties to this incident, and then on about June 23rd of 2022, sent this case over to the Brown County District Attorney's Office for review. That's normal in cases like this. I myself, many times in cases involving disputes between two people, will have a prosecuting authority review it before we do anything else with it, just to make sure it meets their threshold for any kind of official action. The District Attorney's Office declined to take action on this case on a state criminal basis. And then apparently Detective Biller then consulted with the city prosecutor, who prosecutes violation level offenses. And there is a difference. So this would be a city code violation versus a state law criminal violation. The city code violation is almost more akin to like a traffic ticket. It's a one way of looking at it. It's almost like a civil violation versus a criminal one. So the standard of proof is different, and there's some different procedural law around that. And then apparently Detective Biller received communication back from the city prosecutor that she believed that there was enough to go on, and Detective Biller issued Ms. Angus a citation. And I know that there was a trial in municipal court on May 1st of 2023, where the municipal court judge found the defendant guilty of the disorderly conduct offense. Then there was an appeal, because the process from there, if one is not satisfied with the outcome in municipal court, they can appeal to the county circuit court, which the defendant did in this case, and the circuit judge overruled the lower court's decision. So that's the basic timeline. I'm happy to try to answer any questions, obviously, that you have. I know we want to.
Is this issue dead? There's no like appeal for us, right? Or interest or intent to do that?
Correct. As a matter of process, if a municipal citation is, if we are successful on the municipal citation at municipal court and it's appealed to circuit court, we defend that. It's not really a question of whether we do or not. It's an automatic, defense of that determination. And there could be a decision to appeal further, but in this case, we will not be pursuing any appeals action.
Okay. And that's kind of what I wanted to understand, is that at least to where we are today, like there's no further
Correct. The matter's
anticipated legal action.
Yes.
Okay.
I have a question. Chair Galvin?
Yes, go ahead, Alder Burnett.
Chief Davis, Chief Balls had called you on April 25th to investigate Ms. Angus for disorderly conduct. Did he also ask the police department to investigate anyone else relating to this election issue other than Janet Angus?
I don't remember talking about anyone else. The only person that came to my attention out of all this is Ms. Angus, again, having to do with the specific conduct involving the alleged victim in this case, and then the impact on operations at the clerk's office. I don't remember anybody else being involved in that.
So the circuit court judge, Judge Koch, I believe is the name, she had mentioned that it seemed to be a retaliatory complaint. So Matt Razor filed a complaint with the Wisconsin Election Commission on April 25th. So that was the same day that Chief Bolts contacted you to investigate Ms. Angus. Do you find that that was odd, a full 3 weeks after the occurrence, that on the 25th, when Matt Razor filed a complaint with the Wisconsin Election Commission in which he mentioned the Janet Angus situation, that a full 3 weeks, and only at the time the complaint was filed that same day, that's when the investigation was to continue as an officer? Do you find that timing extraordinarily odd?
Well, I think you're, extraordinarily odd. You're asking me to make a subjective judgment. I will tell you that I did not know that there was an elections complaint involving Ms. Angus. I didn't know or completely comprehend the relationship between Ms. Angus and the Razors by that point anyway, because I'd been here for, not all that long, and so I didn't know all of the people involved. In hindsight, one could form lots of different, very understandable opinions about the relationship between those two facts, but for me, in my decision-making, even if I'm asked to do something, if I'm asked to do something that I think is improper or unethical, then I'm not going to do it. It's as simple as that. I've been a police officer now for 30 years, and I have made a very successful career on that level of integrity, and I'm going to do the right thing and let the chips fall where they may. But what I looked at in responding to the request that I got from Mr. Falls was, what are the interests involved? And I have an alleged victim who, it is represented to me, has been impacted pretty substantially by this behavior, so I have that person to look out for. I also have, Ms. Angus, and there's rules for, and there's a whole constitution that protects people in those situations, and so I have to balance that. And then I have to balance the interests of the city and in the public in being able to have the clerk's office run smoothly, particularly on an election day, without disturbances and disruptions to their work. And so, that's what led me to the decision that it was appropriate for us to at least conduct an investigation and see if a crime had occurred. But, if I felt like there was any kind of retaliation or anything underhanded going on, I'm not gonna be part of it. It's as simple as that.
Sure, I've always found you to have impeccable integrity and ethics. I don't question you whatsoever. When Chief Foltz contacted you, do you recall him mentioning that? Because you said you didn't know that a complaint was filed on the 25th. When were you aware that a complaint was made to the Elections Commission?
That's a very good question, and I don't remember exactly. The way I remember this was it was a very long time after we had initiated this investigation. And then I remember not making the connection in my own head between Ms. Angus and the people who actually made the complaint. Now, in hindsight, I understand there is a relationship there and that's all related, but it was sometime, a long time after that conversation with Mr. Foltz that I found out that part.
Okay.
And even then, I have to say, for my own decision-making in this case, had I even known that at the time, certainly that would have factored into my decision, and, maybe what I would have done is asked an outside agency or something to review this, but I still saw a potential criminal issue. If anybody called in on the non-emergency number this afternoon and made a report that an incident like that had happened someplace and they wanted to talk to a police officer about that, I would expect that we would send a police officer and that we would do an investigation and that we would take enforcement action if it was appropriate, not based on anything other than the facts of the incident that happened.
Okay. Final question, Matt or Polly Razor, Matt and or Polly Razor, were you asked at any time during this period of time to conduct an investigation on them in any criminal or civil matter in regards to either criminal law or municipal law?
I don't remember being ever asked to conduct an investigation on the Razors. I had heard of I have some vague recollection of hearing of some other negative interaction that happened between them and some other people in City Hall. I don't even remember what that was, but no. And had I been, I would have done the same analysis. That is there really enough to justify using police resources to do an investigation? But I don't remember ever hearing of them doing something that rose to the level of a crime.
So the best of your knowledge, either anyone within your department, any detective within your department, that they were not approached to conduct an investigation against Matt or Polly Razor?
No, I really don't remember that happening.
Okay. Fair enough. Thank you.
Chief, to get a conviction in circuit court, you have to have proof beyond a reasonable doubt. For municipal court, you have to have clear and convincing evidence. And the difference between that, when I look it up, clear and convincing is information that would persuade a reasonable person to have a firm belief that a proposition is more likely true than not true. So when Detective Biller took this to the district attorney's office, obviously, he's looking at it from the point of view of beyond a reasonable doubt.
Right.
The city attorney looks at it more clear and convincing. With that in mind, is it possible that you could get a conviction on one level and then have it overturned on another level when a different standard is applied to that?
Yeah, it absolutely is. I mean, to your point, those are two very different standards of proof. And, in criminal court everywhere, the standard is proof beyond a reasonable doubt. one place that shows up, though, is to make an arrest for a crime, the standard is probable cause, which means facts and circumstances that would lead a reasonable person to believe it's more likely than not that crime was committed, and that the person who was arrested committed the crime, right?
Which is a different level compared to even getting a conviction at
Yes.
municipal court.
Probable cause is not enough to get a conviction, but it is enough to make an arrest. And, there's a reason why our system has that high of a level of standard of proof for a criminal conviction, but in violation level offenses, typically you will not see that proof beyond a reasonable doubt standard, because the consequences for the defendant are a lot less for a violation level offense.
Okay, thank you. Do you recall, and I know this is going back a ways, yeah, I'm sorry.
Sorry, Alder, just to
Attorney Plunkett.
put a little bit more context on what the chief was saying. So he was correct that there's two different standards of proof, much lower standard in municipal court than in criminal. When a municipal citation is appealed to the circuit court level, the circuit court level is supposed to apply the same
Oh,
standard
I'm sorry, okay.
on the appeal. But if the same set of circumstances were charged at a criminal level, the burden of proof is much higher. That is beyond a reasonable doubt versus at the municipal level, which is what the chief was talking to.
All right, thank you. Chief, do you remember on the 25th about when Chief Falls contacted you about this? I mean, was it morning, was it afternoon, was it early morning? Was it?
I don't remember what time of day it was. I know it was during the day because I was in my office.
Okay, all right, thank you. And in your experience, 30-plus years, you've seen plenty of incidents where incidents are investigated weeks after they take place.
Sure.
I mean, there is no time limit, or is there a time limit that you're aware of on filing complaints for acts that happen?
It would depend on the offense. Most offenses have a statute of limitations where you can't commence a prosecution, but we would have been, within a month, we would have been well within the statute of limitations.
Okay. And all Chief Falls asked you to do was to look into it?
Yes.
Okay. And like you said, if this happened, if someone came up right now and said, hey, A, B, and C just happened down in the clerk's office, you would think, based on your training and experience, that someone should look into that and investigate that.
Absolutely, we do that all the time.
Okay, and you've never, in your entire time that you've known Detective Biller, or anything you know from the past, has he ever given you any reason to doubt his ethics or his ability to perform his job?
Absolutely not.
All right, thank you. That's all I have. Alder Johnson.
Yeah, just a couple of questions. One is, and this is just my naiveness, around your line of work perhaps, but is it normal to issue a citation when you don't have a complaint? Like a complainant, I should say?
You would normally have to have a victim who's willing to aid in prosecution. There are some, like domestic violence offenses, where there's exceptions to that.
And the person that was involved here, did Detective Biller interview them?
Looks like he did, yes.
Okay. And so I assume that was sort of the basis for the issuance of the citation?
I think so. I mean, I want to be a little careful to speculate on questions Detective Biller would be, because he was the one who did all the work. But normally you would expect in a case like this that it's some indication that this person, for example, would be willing to testify if necessary, or to aid in prosecution for the case.
Okay. And to your knowledge, did any staff member talk with Detective Biller or any other member of your staff, or did all of those conversations come directly to you?
I don't know of any conversations that he had with anybody else, and my preference in a case like this is that not happen. The detective needs to be independent to go do his investigation and do what he's got to do.
Okay. This would probably be less for you, Chief, maybe Attorney Bunker, I assume, is who we're directing other questions to.
Sure thing. Here.
And maybe I'll ask that same question of you, Attorney Bunker.
Sure.
Are we aware of any staff that had direct conversations with Detective Biller?
My understanding is that Detective Biller interviewed, let me just pull up my notes.
He did, I think he interviewed the city clerk.
Yes, he interviewed
part of the
the
investigation.
victim, the other individual involved, who did participate as a witness at the municipal trial and at the appeal. And he also interviewed Celestine Jeffries. And that's the extent of staff contact. Once he was towards the tail end of his investigation and was reviewing the facts of what he had found, contacted obviously the ADA for their opinion, and then did forward it to my office so that our city prosecutor could review and see if she would be able to meet her burden at a municipal level. She responded that she would be able, based on the facts that he presented as far as what he had gathered, she would be able to meet her burden, and she did at municipal level.
Okay, and then the police report, is that publicly available?
Yes,
And can that be made available in the council packet?
I think so.
Depending on whatever
Yep,
decisions made here?
sure.
Because I think it would be helpful for those who obviously want, I guess, a little bit more information on this topic.
Sure.
The WEC complaint that was filed on April 25th, and I appreciate the chief's response to that. But when, so if the complaint was filed on April 25th, when did staff learn about the filing of that
We
complaint?
learned about it, so the WEC, it gets filed with the WEC, and the WEC then electronically transmits it to us to put us on notice, because then we have a response deadline. So I was aware of it, ACA Mather was aware of it. Our prosecutor was not. She doesn't handle outside litigation like that, and so she was not aware that there was a WEC complaint pending.
So you were made aware of it on the same day it was filed?
The same day, I think we received it the exact same day, yes.
Was there
Usually
any-
the WEC turns it around fairly quickly to the.
Any
parties.
conversation amongst staff, even if it's water cooler talk, about the
no.
receipt of that complaint?
No, I mean, internally as to what our response was going to be, or kind of at least putting it on everyone's radar, because we were gonna have to start working on preparing a written response to the WEC itself, but not involving the investigation. No, those two things were completely separate.
Okay, any reason in your professional opinion that, I guess, do you have any belief, I guess, that the issuance of the citation was retaliatory in nature
Not in any way.
based on the timing
Absolutely not,
of that complaint?
absolutely not.
Okay. That's all I got.
Alder Hutchinson.
Okay, so we have some facts that happened that seem to be explained, and at our municipal court, there was a guilty plea, guilty verdict. And then it goes to circuit court, and the circuit judge overruled that. Was there an explanation why did the facts change between the first and the second? Why would, it seems to me there were specific things done, and to me, they were
Sure.
pretty clear.
The ruling that we have from the judge is that she didn't feel that the city met its burden. And she was applying the same standard, and that was the determination. She just disagreed with what Judge Dugo had found at a municipal level.
Attorney Brown,
Yeah.
if I could just
Yes,
elaborate.
yes.
Alders, I was actually the one that prosecuted it, and just to further answer your question, presented the exact same evidence at both trials. So the circuit court judge was looking at the exact same evidence that the municipal court judge was looking at, and they just reached different conclusions.
So it was just a decision, no explanation as to why you didn't meet the burden?
Sure, she articulated her interpretation of the evidence, which was different than what Judge Jago had articulated was his interpretation of evidence.
How was it different? I mean,
So for example, Judge Jago, so we have, there was a recording, just a video recording of just the hallway outside the clerk's office. And one thing that Judge Jago focused on, for example, is the number of people in the hallway that turned their head or turned their bodies toward the clerk's office while this interaction was going on, which he interpreted as indicating that there was a loud disturbance happening in the clerk's office. Judge Hawk at the circuit court level looked at that same evidence and said, sometimes people turn their head when people sneeze. I don't take that to mean anything. So it's just two judges looking at the same evidence and reaching different conclusions.
Okay, so the facts really didn't change, it's just the interpretation of how disruptive the situation was?
About whether it met the elements of disorderly conduct, so whether it created a disturbance or tended to create a disturbance.
Okay, and so was the evidence from the witness the same?
Largely the same, I mean, there was, what? 7, 8 months
Yeah,
in
it was
between
a
the two trials, and it had
significant
been
delay.
almost 2 years since the incident itself, so the testimony wasn't verbatim, but by and large, the same facts were presented from all of the witnesses.
Okay.
It looks like Elder Story has a question,
Yeah.
just want to make sure you saw it.
Yeah, we'll get there.
Okay, thank you.
Before I move on to Alder Story, I do want to, just to follow up as to Alder Johnson's questions, I do want to just make clear that the city attorney's office wasn't involved in the actual issuance of the citation. So, while we were internally on one side of the wall discussing and handling the WEC complaint, the citation issuance is not up to our office, so it's very different than the ADA, where the district attorney actually decides, the police present their case, the DA decides whether charges are going to be pursued. In our situation, the investigating officer presents a case, sometimes gets advice from the law department, actually as a matter of course, like, hey, do these facts meet the elements that we need in order for a citation? We give them an answer as to whether they're sufficient or not, or whether we can meet our burden, and then it's up to the officer to actually issue the citation. Once issued, then we prosecute the citation.
All right, Alder Johnson.
So again, just to reiterate and be clear, this
Right.
was completely at the discretion of Detective Biller.
Correct, yes.
Okay, and then when it was adjudicated with Judge Jago, he is independently elected.
Correct.
Per state statute, because sometimes these things can be convoluted.
Sure.
Like I know the relationship, for example, between a police chief or a fire chief and the mayor.
Yes.
Is there any relationship codified in state statute that talks about the relationship between the judge and the executive branch?
No, pretty much the only control really, or kind of the relationship or connection that the municipal court has with the rest of the city as an organization is setting budget and staffing. But as far as his independence and his position, that's completely separate from the administrative portion.
All right, thank you. Alder Stoyer.
Thank you, Chair. There's a couple of questions I have. It relates to April 5th of 2022. During the initial incident, how long did it take for Detective Biller to get to the clerk's office? He was up on 4th floor. Was it Detective Biller that was up on 4th floor? Or was it a different detective?
Yeah, it was Detective Biller. And what we've been able to piece together is it looks like he was notified of this at about 8:45 in the morning. The incident was alleged to have occurred between 8:12 and 8:16 in the morning, so half an hour. But what I don't know is if he was called or if he, in the course of making his rounds throughout the building, bumped into the clerk and that's when she mentioned it to him, or how exactly that connection got made.
Well, I think just looking at that, for me, a half hour, that's a long period of time. And I was thinking that Ms. Angus, would it, in your estimation, would it be her responsibility to be responsible for the upset voter? You know, I mean, she thought she was doing something correct. The voter was obviously upset. It took a half hour for somebody to come down there, so in that half hour, what was going on? Were there people pushing and shoving, or was there, you know, it seems to me that a lot can happen in a half hour, in your estimation.
Yeah, and again, I want to be careful not to speculate. Obviously, I wasn't there, so I don't know what was happening in that half an hour, you know, around the clerk's office. My understanding was this voter left not long after this interaction with Ms. Angus and was no longer there. But like I said, I mean, I don't want to speculate as to
Right.
how
I guess
Detective
that's-
Miller got this
right.
report.
I'm trying to get a handle on the fact that,
Alder
okay, it's
Steuer?
the voting stopped,
Alder
obviously,
Steuer?
with the disturbance. So-
Alder Steuer,
Yes,
do you have just a second? The attorney would like to speak?
I just wanted to clarify, the incident ended when a member, a staff member who was working in the clerk's office actually escorted the voter to her vehicle because the voter was nervous about leaving by herself. And then the whole incident ended at that point. There was no like ongoing situation that Detective Miller was responding to. The testimony at trial was that he was asked by the clerk to come down and discuss the situation.
okay. Well, that makes sense. I just wanted to get a clarification as far as when an officer showed. So, in the estimation of you folks there, how long was the clerk's office, not closed, but temporarily shut down for voting? Was it just a matter of minutes, or until the voter was escorted out of the room? Is there any idea how long it was, that there was the disruption, how long it actually took?
Sure.
So that the voter, yeah, go ahead.
From when the voter entered the building until she left was less than 5 minutes. So it was just minutes that the disturbance was ongoing. However, again, and I apologize, I keep referring to the testimony at trial, but I just want to make sure everybody's clear that that's where it's not just me saying this is where the things I'm saying are coming from. But the testimony at trial from Clerk Jeffries was that the business of the actual clerk's office was disrupted throughout the day. People were, having
Okay.
difficulty, eating. People were visibly upset. It was very disturbing to the staff.
So it seemed like it wasn't all that long as far as the delay, maybe for a few minutes, but, all right, those are just basic questions that I had, and I will look over the report as well, so thank you for that. Thank you.
All right, thank you, Alder Steuer. Alder Eck?
Yeah, I don't really see a lot of attachments on, so I guess I need to look at more of the information on it.
I do have some follow-up questions. When was the law department made aware on the 25th that there had been a complaint filed with the WEC?
I don't know the exact timestamp of when the email came through from the WEC. but
Morning,
that's-
afternoon?
More,
Morning?
So it looks like Clerk Jeffers was notified at about 9:45 in the morning and forwarded the email to Attorney Bunger a few minutes after that.
Okay, so did anyone share this email with Chief Falls?
Yes, I did. As a matter of course, anytime we have any kind of litigation, I usually alert Chief Faults of that.
Okay. And Chief Falls, then you notified the chief, expressed your concerns to him, and he conducted steered the investigation.
Yeah, so I mean, when I notified Chief Davis, it wasn't in connection to the complaint. The notification to Chief Davis is because the city has an obligation to provide a safe environment to the public and to employees. So I was under the understanding that PD was reporting to PD already before that. So I followed up, just kind of see if he was aware of it. So that was a misunderstanding because I don't think PD was aware, or they weren't following up prior to April 25th. So if I would have known that, I probably would have followed up earlier, but I mistook that they already were aware of it.
All right, thank you. Any other questions?
Alder Burnett has his
Alder
hand raised.
Burnett?
Yeah, obviously, Detective Biller was on site and he was aware of the disturbance. The way that the city clerk's office and some people are making it seem that it was a huge disturbance. With Director Faults say the police, were they aware of it? Well, the police were aware of it. Lieutenant Biller was there. I mean, if he saw something that would have raised some criminal action or even a municipal citation, I would have assumed, being a good detective there at City Hall to provide security, he should have initiated that on his own. The city contacted the DA's office to see if there would be any criminal charges, and the DA declined. So I have a really hard time believing from April 5th to April 25th, or April 4th, or whatever it was, a full like 3 weeks, this huge disorderly conduct that led to a municipal citation with the recommendation of a criminal action. I just have a hard time believing that the police would not have been aware of that and made their own independent analysis of whether to pursue it before Chief Falls initiated the call to Chief Davis. I'm really having a hard time with that, I'll just be honest. I'm very skeptical. The issue at hand right now is, was this a retaliatory action? I think that's what Alder Weary's communication was. Was this a retaliatory action? And that's what we really need to be talking about. Was this retaliation? Because if for 3 weeks the police were not contacted, I doubt that this was as severe as some people within City Hall claim it to be. So we should really be talking about if the action set in place once that Wisconsin Elections Commission complaint was made, did that lead to a snowball where potentially a citizen's Fourth Amendment, a citizen's rights were violated? That's really what we're talking about here. So I'm questioning the timeline.
Well, I guess you kind of contradicted yourself, Alder Burnett.
How so?
You said that the chief has the ultimate integrity in how he's conducted himself and done his job. He's told you he wasn't asked by Chief Falls to investigate this for the purpose of retaliation. The chief turned this over to Detective Biller, who independently investigated it, and you've said that you've had no problem with his work in the past. He's the one that made the decision to take it to the district attorney. He wasn't asking for criminal charges, he took it to the district attorney for an opinion. When the district attorney declined, he then took it to the city attorney, who looked at it and under the standards of clear and convincing, felt that this was a chargeable offense, that there was probable cause. No one's saying this was a huge disturbance. This was a disturbance that has caused someone to cry, an elderly woman. And I think you would describe if someone went up and made your mother cry, that was a disturbance of some sort. Not the kind where people are rolling on the ground, cursing each other, yelling and screaming and throwing punches, but a disturbance of some sort. And so you're saying that you suspect that this is retaliatory, but you've just commended the chief on his ethics, his integrity. The same thing with Detective Biller, and they're both saying that they were not told to do this for any other reason. So I don't know where you're drawing this conclusion from.
Well, I disagree with your assessment, first of all. I don't agree with the way that you laid it out. I'm going off of what the city employee said. Lieutenant Biller was there on site. I don't automatically assume that he doesn't have integrity. However, if this was something that he witnessed, or not witnessed, but he was in the building and he had the opportunity to explore this, the only way that this thing initiated was Director Folds contacting Chief Davis. Chief Davis did the correct thing. He started the process, but that only occurred after a Wisconsin Elections Commission complaint was issued. I don't think I contradicted myself at all. I'm just pushing back on some of the things we're hearing from city staff, and I would argue that you should push back just as thoroughly.
Okay, and I will. So let's assume that Chief Falls contacted the chief of police with the sole purpose of retaliation. Now unless you're assuming the chief is part of this conspiracy.
The act was the retaliation.
So all he did was he looked at the situation, he listened to what he knew, and he felt that there was enough there for Detective Biller to look into this further, to contact the victim who was no longer there when he got there. He did that, and he felt independently that there was enough probable cause, again, probable cause, for a charge to municipal court. Now,
Should we be in closed session?
No, I mean, I don't mind airing this out in public.
This is all, just to clarify, Alder Eck, this is all public knowledge that was presented in trial court and at the appeals court level. If we start getting into any kind of level beyond that, well, I'll advise to go into.
But I
Okay.
don't
Because I have
see,
something that I think maybe it should be.
I don't see then how we can draw a conclusion that this is retaliation on the city's part if two of the main people involved in this investigation were doing it independently. Looking at the facts that they have. I mean, officers all over the United States have discretion whether to make charges or not. On many incidents that they see and experience, many people don't want anything done. People get punched out, they're bleeding, officers get on the scene, I don't want anything done, I don't want to press any charges, are you sure? Okay, they go on. But other time, officers can see things that happen and say, I don't care if you're going to press charges or not, based on what I know, I'm going to file charges regardless. I mean, so these things can happen. You'll have to show me how the chief and how Detective Biller are helping the city to seek retaliation here. Go ahead.
I'm not accusing the police force of retaliating. I'm simply saying that an independent circuit court judge of Brown County, to which Ms. Angus appealed this municipal court's decision to, an independent judge, independent of the city, maybe didn't rule that there was retaliation in her ruling, but she made significant comments that this appeared to be a retaliatory action from the city. Alder Galvin, this is an independent person, not Jesse Burnett, that made that assertion. So we have a county official who has no vested interest in this case, no conflict of interest, because she is not tied to the city of Green Bay. She independently said that this appeared to be a retaliatory action. Whether it is or is not, that's really your opinion or my opinion, but I'm just going off of what the judge's opinion was, and that's a pretty serious thing. I don't know how you can have a higher court rule that the actions of the city government appear to be retaliatory only after the citizen filed a complaint to the Wisconsin Collections Commission that an investigation continued. That appeared to her to be retaliatory. And I'm just telling you what she said, and I kind of agree with it, that it does appear retaliatory. That's what we're getting at. I love Chief Davis. I think he has a ton of integrity. But the actions that set in place led to a citizen of Green Bay who initiated a complaint, who witnessed what really was an illegal action that, I know there was some gray area there, but it appeared to be an illegal act of collecting 2 ballots at that moment. She did something, maybe it was disorderly, maybe it was not. 2 courts have decided, split decision on that, but it was appealed to the circuit court judge, the higher of the 2, courts, and they said that it appeared to be retaliatory. I don't know how you can just overlook that, Elder.
And I'm not overlooking
That seems to be
it.
pretty serious.
And that's the thing. And also, it was the Razors that filed the complaint, not Jen and
Here's
Angus.
those- Yeah, well, who cares who filed it? The fact is it was filed, and that's why I asked if the Razors were investigated.
Well, then what's the retaliation? I'm not getting the retaliation. There's no retaliation against the Razors here. It's against,
Retaliation against Janet Angus for reporting, she's the one that was charged with disorderly conduct. The retaliation was against her.
all right, Attorney Bungert.
Yes, so, and just to kind of counterpoint, or at least to provide a full perspective as far as what the courts have looked at regarding this issue, the municipal court and Judge DeGo also made rulings on the allegation of vindictive prosecution, which the defendant and her attorney did provide. So I'll turn over to Attorney Mather to provide more information as to what the judge found in that review.
Yeah, very briefly, but before I do that, I just want to make it very clear, the acceptance of the 2 ballots on that day was not illegal, and the WEC found that that was not inappropriate for Clerk Jeffries to accept that ballot. That needs to be crystal clear for everybody. Second, as far as the, what Judge DeGo said, Ms. Angus's attorney made the argument that it was selective prosecution, that it was only being done because of the WEC complaint. And Judge Jago went through all of the steps and said that there wasn't any evidence. There wasn't evidence that other people had acted similarly and had not been cited, but she was cited just because she was exercising her First Amendment rights or because she had filed the WEC complaint. So again, you have two different judges undergoing the same, actually, Judge Jago actually went through the legal analysis and found that there wasn't selective prosecution, and Judge Hawk specifically said she was not making a ruling on the vindictive prosecution issue. So you have one judge who looked at it thoroughly and said, I'm not finding that happened, and you have another judge who made comments but didn't make a ruling on that issue. So once again, you have two different judges reaching two different conclusions. This is not uncommon.
All right, Chief Davis.
Yeah, and Alder Burnett, I appreciate your concerns, and I think it's healthy for us to have this conversation. One thing that I would point out is, again, I never had the impression that anybody at City Hall was trying to retaliate against Ms. Angus, but even if, I can't tell you what Mr. Faulds' motive was in making that call, but what I can tell you is part of the safety mechanism that I think worked in this case was, again, I'm just looking at the facts, and if somebody asks me, and there are times where people ask, they'll either through some relationship they have with me, they will ask me, or they'll ask the police department to take some official action where we say no. And if I didn't believe, based on the facts, for whatever reason, they landed on my desk that day, if I didn't believe that it was appropriate for us to initiate an investigation and find out what happened, then I would have said no. So, even in the worst case scenario, had there been some ill motive from someone making a call to me, I'm going to stop it right there. If I see something unethical that somebody's asking me to do, I'm just not going to do something that's not going to use the criminal law and the criminal process in that way. That's wrong. Hopefully that makes sense. I mean, again, I'm one of the safety mechanisms, along with the judges, who then that's another safety mechanism that people have in this process to make sure we don't make a mistake.
Alder Eck.
Okay, so bear with me, because I think it does matter, because Director Faulds had asked for it to be checked into because someone was visibly upset. On the same day, not long later, my sister was witness to something that happened, and I don't know if you want to say an altercation, it wasn't like physical, but words, with the chief of staff and Holly Razor. And my sister happened to be witness. Maybe you didn't know it, but that was who came talk to you.
Yeah.
And filed a complaint, gave the whole scenario to Director Faulds. And I'm not sure if the police got called about that, but I will tell you, based on what my sister is very good at recalling, she gave you the whole thing and she gave the whole thing to me. And the person who was coming in, a citizen, was extremely upset with the interaction between the chief of staff and Holly Razor in front of this woman. So did you ask anybody to investigate that?
Human Resources looked into that, and there was a video of that, and that was reviewed. It's also reviewed with the law department. It was also reviewed with another alder person as well. So with this situation with Ms. Angus, like I said, we needed some department to look into it on the basis of we are obligated to provide a safe work environment and a safe environment for the public. Either the PD was going to look into the incident with Janet Angus in the clerk's office, or the HR department was going to. And that second situation you're talking about, Human Resources looked into it.
Okay.
And to clarify, sorry,
yeah.
just to interject, clarify as to process, that was a situation where a member of city staff was being complained against as being, as potential wrong behavior. And so then it's appropriate for Human Resources to investigate this. Well, in this situation, it was a member of the public involved in the altercations.
No,
over
it
which-
wasn't, it was a member of the public in this case
But
who was
the
extremely
complaint of-
disturbed by it.
But I'm saying the complaint, the person that's alleged to have caused the disturbance or the altercation was a member of staff. And in
No.
this instance, it didn't, the
No.
staff was basically on the receiving end of the disturbance. And the member of the
If
public.
that person who witnessed this, that was disturbed by it, had called the police, then the police could have investigated
Mhm.
and then issued a citation if they felt one was warranted, correct?
Absolutely.
Did that person call the police department?
No, but it was an elderly woman, same thing, I mean, and she just was very visibly shaken about the interaction, and when, she had to drop off her ballot and then she left.
So
So
who
the
did she-
complaint was technically
I would-
Polly Razor, and then, actually Matt Razor asked my sister to come in because she witnessed it and talked to Director Fultz. so.
I would recommend, if we want to go down this line of questioning a little bit further,
Not
since we're
really.
going into a personnel investigation,
Right.
Well, that's
we should
what-
go into closed session.
Yeah.
Yeah, I would,
That's what I was saying.
Yes.
What I have to share may be a closed session situation, but
Sure.
I'm just thinking they seem similar to me. That's why I'm bringing it
Right.
up.
So
How
that's
is
the
it
big
relevant?
distinction, is
Oh,
that it
it's- and
involves
it's
an
not.
employee.
It's not relevant.
It's not relevant.
That's why I said, bear with me, but I want me to see, it was Director Fultz that called for the investigation to the other thing, and he was also involved in this,
Yeah,
and that's why I'm
and-
asking, what was done about that? They're
Okay.
both similar,
And things were done.
on the
So-
same day.
Right, but things were done appropriately.
Well,
What-
I
what
don't
I'm-
know,
what
I
I'm
don't know
hearing-
what the end result was.
All right.
Okay, what I'm hearing is someone observed something happening, 2 ballots being given to the clerk, which turns out to be totally legal. And at the same time, that person raised their voice and caused an incident. I mean, that's a fact. Even if it was a sneeze or people were looking from the hallway in, it would happen at a ballot place. I don't know about you, when I go into a ballot, it's almost like going into a church. You're going in, it's quiet. You're supposed to do your duty and leave. And you say hi, thank you, and leave. To hear a raised voice, that's disturbing. To hear it for a minute, that's really disturbing. So I think what's happening is, we're looking at this disturbance as just a little disturbance, but it happened where people were handing in their ballots. That's disruptive. Now, I also heard the attorney say it affected the workers in the office all day long, okay? So it wasn't just a little thing that happened in the hallway. It happened where people were voting, and it was disturbing, and someone was brought to tears, had to be escorted to their car. And so what I'm hearing is an alder is asking an investigation in this. I don't think there's anything where to go. We've had a good discussion, it's all in the open. I don't see anything bordering on something needing to be investigated at all. I see a lot of politics in play here, and every time politics comes into play, it screws things up. I don't see anything that should be investigated. The time has already been spent. Why are we going to even consider spending more time on this? If anything, the city should go, appeal, but they're not. Let's put an end to it. I think we should put an end to it. This whole thing, I think, was appropriately handled from something that should have never happened at the ballot place. So that's my thinking at this point. I haven't heard anything that even comes close to needing an investigation.
Are you making a motion?
I would motion to table or file or whatever it is that ends this. What's
Receive and place on file.
receive and place on file.
Is there a second?
I'll second it. Look, can I speak?
Sure,
Yeah.
absolutely.
So, it's There's a lot going on here. And I think, you know, we gotta go back to what the original communication is, right? Which is to consider and possibly hire an external HR investigation. You know, and that's really what's before us. And I think this discussion is what obviously helps inform the decision of whether or not we want to do that. I do agree with some of the points that Alder Burnett and others have made, and including what our Judge Hockett said, that it does appear to be retaliatory in nature. It looks fishy. It does. But coincidences can look fishy. And I do, admittedly, like, I have a hard time with that. But at the same time, what I'm hearing from our chief is that this was independently conducted. It was independently conducted. So if we hire an HR investigator, what's gonna happen? We're gonna spend taxpayer dollars to bring someone in here to hear the same story that we all heard today, right? That's the reality. So the question is, do we really wanna spend money on that, to have someone bundle this up into a report when all we have to do is rewatch this video? This is the investigation, quite frankly. And at the end of the day, I hear conjecture, I hear accusations, I hear suggestions, but I'm not connecting any facts together on this that not just suggest, but prove that this was a retaliatory act. I have my doubts too, meaning that I look at this and say, gosh, there are certain things that are happening here that just seem too coincidental. But if we order an HR investigation here, when again, we've conducted it right now, here's my fear is we, even though the actual citation issue may be over, and correct me if I'm wrong, Attorney Bungert, but it's very plausible a civil matter could come out of this yet with Janet Angus versus the city of Green Bay. That's possible, right? So I'm looking at this saying, why would we want to hire an investigator to produce a report that could potentially be used against us? That makes me a little bit uncomfortable, quite frankly, when I am elected to protect the citizens of Green Bay. And I think that there's another side of this discussion, right, which is, and Alder Burnett made this point, and that is to protect the rights of Miss Angus as well. She deserves that protection, but I feel like that protection went through that due process, and a decision was made. And I think now what we're here to do today is make a decision about whether or not we want to hire an investigation, so that somebody can be held accountable without any facts that have really suggested someone is accountable. So I'll support the motion. I think the reality is we're going to talk about this probably more at council. That's just reality, and that's obviously, I'm sure Alder Wery will maybe have some additional information or want to shed some additional light on this. I personally would like to review that police report, which it sounds like can be included in the packet. I think that's important that all of us review that as well, just to make sure that, you know, we've asked some questions here, we've gotten some information. I just want to be sure that we're not missing any facts as a committee, perhaps, that, you know, we didn't ask the right questions maybe. So,
Can
we just,
yeah, I'm done.
I want to make
So-
sure you're done.
I'm the chair, so.
No, I
just
know, I'm
fine. So,
asking you.
Are you done?
Yep, I'm done.
Okay, go ahead.
I was asking you if I can speak. I just thought, could Detective Miller be here?
Well, Detective Biller is retired, if you want to call and ask him to come down from
Well,
wherever
because
he's at.
he's the one who really has the answer to the questions that we're asking. And not, you know, nothing against the chief, I'm just saying, he was the one who did the investigation.
He's retired,
If
so
if you
there's-
want to contact
I
him,
can't
see
compel
if he's
him
willing
to
to
come
come
in
in.
because he doesn't work for me anymore.
I do believe Detective Biller answered the question as to his opinion on the issuance of the citation at both trials. So
Is that
I
gonna be
believe
included in
the
the packet?
transcript of the appel, we can include the transcript from the appeal.
We don't have a transcript of the municipal decision, there's only an audio
Audio.
recording.
But we can provide the transcript from the appellate decision, and you can see the questions that the judge asked, the questions that were asked of Detective Biller while he was testifying and his answers.
That would be helpful. Thank you.
Is it possible, Attorney Bungert, if this had been appealed to a higher court, that they could have ruled in our favor?
Potentially, that, I
And
mean,
and then it
that's
could have been
that's a
appealed
complete
higher up, and
guess.
it could have been ruled again in Attorney Angus's? That's how the system works?
Correct, that's the purpose.
All right.
The only court that has the final word is the US Supreme Court, that's it.
All right. Are there any other comments?
Burnett has a
Alder
question.
Burnett.
Yeah, I mean, I can support the motion. I haven't talked to Alder Weary about this, so I don't know what his intention is. Probably has a spirited debate at council in a week. I'll just say Attorney Mather had pushed back a little bit when I said that it was a legal act that exception to health. I know that, it was legalese and some of the response to the complaint, but I remember seeing several clips about it, and one of the clips in the 5-page decision letter issued was, in short, the commission, which I'm assuming is the Wisconsin Elections Commission, has determined that the complainant has shown probable cause that the respondent violated Wisconsin statute. So
Hold on.
when we read things that say that there's probable cause that we violated state statute, that's what I was getting, whether it was illegal or not.
Hold on.
The commission ruled almost kind of a split ruling against the city. So that's what I was getting at. Not the city doing anything illegal. It's just when you read that, you can assume that maybe we did do things the right way. So with that, I'm fine with the motion. I don't like it. I think that eventually, from rumors that I've heard, that Ms. Angus may sue the city, which is her right, of course, for violations of her civil rights. So maybe this whole process gets laid out there in a higher court of law. I'm hoping she doesn't sue the city, because I'm a resident and representative of the city. But if there's something deeper and more disturbing here that can be proven, then perhaps that's the route that needs to be taken by someone outside of the city, suing the city.
Attorney Bungert.
Yes, just to quickly frame the distinction of what Alder Burnett was discussing. So with respect to the policy that was employed at that time, that was the finding of the WEC with respect to abuse of discretion. As to the specific event involving Ms. Angus and the voter, the WEC found that there was no abuse of discretion as to that specific event. The policy itself was not proper, and it already had been changed and updated to be proper by the time that the opinion came down from the WEC. So there was nothing, no remedial actions that needed to be taken. Was there anything else that I missed, or anything else you wanted to add?
No,
Okay,
that's accurate.
perfect.
All right.
Last thing, if I could, this will be the end of it, but Attorney Bungert, in
Yes.
regards to that,
Mm-hmm.
do you think it's possible if Ms. Angus saw something that was disturbing to her, that her interpretation of the law as an attorney herself and as an election observer, she noticed something that she considered illegal based on her duties and her legal background? Do you think it's possible that our city staff or city employees don't like being challenged on that? I think there's some animosity that grows in our community around election issues. So when Ms. Angus recognized something that was illegal, or in
Sure.
her view, approaching Ms. Jeffries, do you think Ms. Jeffries could have handled that better, that this whole thing could have avoided the escalation that occurred?
Sure. Before I defer to Attorney Mather, essentially the proper protocol for any concerns regarding elections, whether there are violations or beyond the status and what is afforded to election observers. This was election day. There was no voting happening. It was just the return of absentee ballots and central count. That was the only area where there were observers. Generally speaking, anybody witnessing any kind of election activities, whether an observer or not, the proper process is to call the WEC. The WEC has a specific phone number for complaints or allegations of things that are happening that are, suspect. And so that is really the proper process for filing any kind of complaints or reporting any kind of suspicious activity. It doesn't have to be a formal complaint. And that's really the proper process.
And I
Yes.
would also note that Clerk Jeffries testified under oath at the trial that that she absolutely would have addressed Ms. Angus's concerns had she not interrupted, and she actually asked Ms. Angus to wait until she was finished speaking with the voter, and then she would address Ms. Angus's concerns. So I think it was more about how the concerns were raised than the fact that concerns were raised at all.
Okay, thank you.
Okay, we have a motion to dismiss, we have a second. All those in favor say aye.
Aye.
Aye. Any of those opposed?
There's a motion to receive and place on file.
Receive and place on file. Too much legalese. All right, so the motion was to receive and place on file. All those in favor say aye.
Aye.
Any of those opposed? That passes unanimously. Thank you, Chief. Of course. All right, on to item number 5, for consideration with possible action to amend the City of Green Bay Personnel Policy 9.12 holidays to reflect the practice and discussion from the January 30, 2024 Personnel Committee meeting confirming the removal of the floating holiday in lieu of the day after Thanksgiving for Department of Public Works employees.
That was a mouthful, sorry
Yeah.
about that, it was annoying. So we talked about personnel on the 30th, January 30th, that DPW employees no longer have the floating holidays, so we don't have floating holidays for any of our employees. So it's just, we're hoping to correct it and, go into personnel committee to get that finalized. So we're just, one thing I would ask for in the motion is to, I have in the packet that it would be effective March 1st. It should say effective March 20th if you guys wish to approve it.
Any
Motion to approve effective March 20th.
Second.
All those in favor say aye.
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 And that passes unanimously. All we have left, gang, is, next meeting is April 9th, 2024.
Move to adjourn.
Second.
All those in favor?
Aye.
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 And that passes unanimously. We are adjourned.
These personnel committees